nationals. So let me just share my screen. Ayan. Kita po ba ang aking presentation? Okay, salamat. So to start off, let's first talk about some principles and context behind the department order. So as we know, the employment landscape is constantly evolving, driven by globalization, technological advancements, and shifting economic needs. So in this dynamic environment, DOLE reaffirms its shared responsibility to build a fair, inclusive, and efficient labor market, one that prioritizes and safeguards the welfare of Filipino workers while recognizing the valuable contributions of foreign nationals. So this balance is at the heart of our labor and employment policies anchored with the Philippine Labor and Employment Plan, or PLEP, 2023 to 2028. So the issuance of DO 248 series of 2025 marks a pivotal step forward in this regard. So this policy strengthens our regulatory framework for foreign employment and ensures that foreign nationals in our workforce contribute meaningfully to national development while upholding the rights and welfare of Filipino workers. So as mentioned earlier, this was signed by DOLE Secretary Benvenido E. Laguesma on January 21, 2025. So this DO consists of 9 rules spanning general provisions, application requirements, cancellation and revocations, exemption and exclusion, employer and foreign national duties, prohibited acts and administrative penalties, and the management, administration, and enforcement. And we will run through this. We will run these rules one by one. Also, this new department order was crafted through thorough and extensive consultation with key stakeholders, the National Tripartite Industrial Peace Council, and a rigorous review process of DOLE to ensure that it aligns with our national and sectoral plans and policies. So it was officially published in the Philippine Star last January 25, 2025, and took effect February 10, 2025. So the DO highlights two main state policy objectives, and we want to emphasize on this because ito yung ating babalik-balikan as we go along with the presentation. So number one, one of the most important policy objective is the preference for Filipinos. So DO 248 upholds the constitutional mandate of giving preference to Filipino workers in employment opportunities. So this ensures that our local workforce is prioritized, especially in sectors where Filipino talent is available and capable. And employers must comply with this policy by hiring qualified Filipino workers before considering hiring foreign nationals, except in cases where specialized expertise are required. And then number two, promote human resource development. So beyond employment preferences, DO 248 also emphasizes the need to invest in human resource development. This means enhancing the skills and competencies of Filipino workers through continuous training, upskilling, and capacity building programs. So by promoting workforce development, we strengthened our human capital, making Filipino workers more competitive locally and globally. So this also aligns with the government's broader labor policies such as skills training programs under TESDA and the employment facilitation initiatives by the Department of Labor and Employment. So DOLE shall operationalize those policies through the following. So first, employers hiring foreign nationals in the Philippines are required to register and obtain work permit to prioritize Filipino workers and ensure that foreign employment aligns with national development. Secondly, foreign nationals can only be employed in the Philippines if no qualified Filipino is available or possessing the necessary qualifications. Third, the issuance of the AEP, or the Alien Employment Permit, must be non-discriminatory and based solely on objective factors. inherent job requirements, and bona fide occupational qualifications. This is to ensure that a fair and rigorous evaluation process for all applicants, whether they are foreign nationals or Filipino. And lastly, ensures that the Philippines adheres to international obligations and best practices in employing foreign nationals, including principles outlined in the General Agreement on Trade and Services and the ASEAN Framework Agreement on Services, or the AFAS. So this necessitates balancing the country's right to regulate foreign employment with the need to align policies with global frameworks on labor mobility. So as to the salient features of DO248, the new rules include the labor market test with its additional measure. Later on, we will emphasize on how we will conduct the labor market test. And then the economic needs test. This is to assess the economic implications of employing foreign nationals in specific sectors, occupations, or industries as applicable based on current labor market information. And then the new rules likewise includes the implementation of the understudy training or skills development program for covered establishments or those companies registered under Foreign Investment Act that enjoys fiscal incentives, those registered under Public Service Act, and those those belonging to the strategic investments under Executive Order number 18 and subsequent issuances. Okay, so that's for the introductory part. So let's go to the main department order itself. So let's start with Rule 1, General Provisions. So as provided by Section 2, Article 12 of the 1987 Philippine Constitution, it says that the state shall promote the preferential use of Filipino labor, domestic materials, and locally produced goods, and adopt measures that help make them competitive. And then moreover, the said provision was strengthened through Article 40 of the Labor Code of the Philippines as amended, stating that the foreigners or foreign nationals seeking employment in the Philippines and their employers must obtain an employment permit, which is the AEP, from the Department of Labor and Employment. So this permit is granted only after a thorough evaluation by DOLE to ensure that no qualified Filipino citizen is available for the specific job role being offered to the foreign national. So for Rule 2, let's start with the requirements and procedure in applying for AEP. So for Rule 2, this section enumerates the requirements and procedure. So I am now showing you a more detailed flow chart of the AEP application under DO248 and the issuance process for better appreciation. So as a requisite to the AEP application, the applicant must first comply with the labor market test through publication that requires the employer applicant to post the job vacancy or vacancies in 3 media or ways. So this will be the newspaper of general circulation, the field job net, and the concerned public employment service office having jurisdiction over the place of work. And then only after the lapse of the 15 days from the date of publication in all 3 media can the applicant file its AEP application with the DOLE regional office. Afterwards, the DOLE RO or the regional office evaluators will then conduct a pre-evaluation process to check the completeness of the submitted documents. So note that in the pre-evaluation phase, the RO will not yet dwell on the authenticity or veracity of the declaration in the application. It will only be based on the completeness of the documents submitted to DOLE. So if documents are incomplete, DOLE shall return the application documents to the applicant for completion and compliance. So on the other hand, if complete, the applicant will be notified and ordered to pay the prescribed processing fee of 6,000 pesos for every year of validity and additional 5,000 pesos for every additional year or a fraction thereof. So after a payment of processing fee, dito na yung a more thorough evaluation and verification process na i-conduct ng DOLE Regional Office, guided by Section 8 of Rule 2 of DO248. So application shall be processed for a period of 15 working days, and then we have a separate discussion later on the evaluation process. So also, if the DOLE regional office deems it necessary, a verification inspection will be conducted in the employer's premises or the foreign national's intended workplace. So yung inspection, kasama na siya dun sa 15 working days ng pag-process ng AEP. Unlike dun sa previous guidelines, nakaseparate yung process cycle time if may, or magsa-stop yung process cycle time if may inspection na ikakonduct si DOLE during the before the issuance of the AAP. Further, in evaluating the AAP application, the regional office will be on the lookout for other grounds of denial under Section 10, Rule 2, such as verified information or report of any malfeasance committed by the foreign national, any subsisting or previous disqualification of either the employer or the foreign national. Thus, if the DOLE evaluators find that there are no grounds for denial, they will endorse there are grounds, sorry, there are grounds for denial. They will endorse the application to the RO's Mediation, Arbitration, and Legal Service Unit of the regional office for review and drafting of the order of denial. In its endorsement, the evaluators must indicate its initial findings, which made them recommend the denial of the application. If upon review, the MALSU or the said unit finds that the denial is proper, an order of denial stating the grounds will be drafted for the regional director's approval and issuance. So on the other hand, if wala namang nakitang grounds for denial, the evaluators will then endorse the application to the regional directors for recommendation of approval. Note that the regional director still has the discretion to review the application despite the recommendation of the evaluators. Hence, if the regional director finds that the application has grounds for denial, the application will also be endorsed to the MALSU for drafting of order. Otherwise, if the regional director approves, it will then be endorsed to the AAP unit to proceed with the printing and the release of the AAP cards. Okay. So still under Rule 2, posting of job vacancies, as mentioned earlier, it will now be in 3 ways. So number 1, the newspaper of general circulation. Number 2, the PhilJobNet or the official job matching portal of the government. And then number 3, the Public Employment Service Office having jurisdiction over the intended place of work. So the publication shall state the employer's intention to employ a foreign national and shall include the following information. So pag nag-submit sila ng publication sa mga media na to, dapat may mga information such as the name of the employer, yung address niya and yung nature of business, and then position na i-fill ng foreign national including yung job description and functions for that position. And then qualification requirements for the position. This includes yung education, experience, professional license, skill certification, or other specialized training if kailangan dun sa position na yun. And then work location and address where the foreign national will regularly perform duties. So kailangan declare din kung saan mag-o-office yung foreign national. And then yung name and city of residence of the foreign national applying for AEP must also be included dun sa posting. And then statement from the company confirming that the foreign national is able, willing, and qualified to perform the job. And then the intended employment duration, and of course, yung details of the DOLE regional office kung saan i-apply yung kanyang AEP. And then this publication shall be valid and effective for 45 days. So to reiterate, the publication requirements in the new guidelines mandates that the job vacancies be published in all 3 media or ways. So yung start nung pagbilang nung 15 days before makapag-apply ng AEP sa DOLE ay dapat makompleto muna itong tatlong publication requirements natin under the new guidelines. Ayan. So as such, the applicant shall be required to submit or attach proofs of this publication or postings together with the AEP application pag sinubmit na siya dun sa concerned DOLE regional office. So for the newspaper, yung newspaper clipping sa dyaryo, and then for the PhilJobNet, yung screenshot or printed copy nung field job net posting. And then sa peso, stamp receive ng peso or yung endorsement from DOLE field office or kahit yung panag-issue si peso ng certification indicating na nag-post sa kanilang job boards yung employer. So later on, meron ding specific slides on the publication. So for the PhilJobNet posting, may we note that employer without existing PhilJobNet account need to be accredited by submitting basic requirements for this purpose, such as the business permit, BIR certificate of registration or form 2303, and the SEC registration if corporation or DTI registration if sole proprietor. So itong accreditation naman with the PhilJobNet and the requirements can be submitted online. So need to after you create your account sa PhilJobNet, if magpo-post kayo ng job vacancies, you need to submit yung mga basic requirements para ma-approve yung request nyo for posting sa ating PhilJobNet. So for the AAP part, so step 1, employers with existing account in the PhilJob are advised to use the login page, and then employers who have not registered have to sign up in order to post their vacancies in the PJN as mentioned earlier. And then step 2, upon successful login, employer shall click the post a job vacancy link dun sa ating PhilJobNet. Then under the post a job vacancy page, the system will ask for information on the position title, work location, and other information on that specific vacancy, including the foreign nationals candidate's name. So kailangan din pag nag-post si employer sa PhilJobNet, i-declare niya rin doon kung sino yung foreign nationals na i-apply niya ng AAP. So for step 3, yan, i-indicate na doon yung details ni foreign national, yung kanyang last name, first name, middle name, and ang kanyang last name, and if my extension name. And then step 4, employers have the option to edit the profile of the foreign nationals and then the information on the job vacancy postings. And then just click, once na updated na lahat, you just have to click the save button. So that's for the PhilJobNet AAP module. And then for the peso naman, as mentioned earlier, peso shall publish or post the said vacancies in its own job boards or other official media such as their Facebook page or kanilang website ng local government unit. And peso will act to certify that the applicant has indeed published in the PhilJobNet. So for the purpose of certification is what it was discussed and agreed na yung mga acceptable na pwedeng ipasa sa DOLE as number 1, yung na-mention ko kanina, certification from peso. Number 2, na sinertify ni peso yung endorsement ni DOLE Field Office na nakapag-post nga si employer sa ating PhilJobNet. And then, or number 3, yung isa-stamp receive nila yung isa-submit ni employer na proof na diretso na pumunta na sila sa peso na sinubmit nila yung proof of posting ng job vacancy sa PhilJobNet. Since ang mga peso naman natin ay may access din sa PhilJobNet, at nakikita rin nila yung mga nag-post na employer sa ating PhilJobNet. Ayan, okay? Still under Rule 2, we go now to the documentary requirements. So the new department order enumerates the following documents in support of the AAP application as follows. So flash on your screen yung mga requirements. First, for the new application. So nandyan yung duly accomplished application form including the employer registration number or ERN. So itong employer registration number is crucial kasi pag nag-a-apply ng employer registration number, sinasama na doon yung mga corporate documents para sa subsequent applications nyo for AAP, hindi na namin kailangan i-require ulit na mag-submit kayo ng corporate documents unless merong updated or meron ng bagong corporate documents for that specific year. And then of course, yung photocopy of the passport bio page of the foreign national with valid and appropriate visa. And then yung kanyang TIN issued by the BIR. And then of course, yung appointment or contract of employment. And then yung certificate of registration with articles of incorporation and bylaws and updated general information sheet from the SEC, or a business or mayor's permit or certificate of registration from the SEC documents or business permit yung isasubmit niyo na lang sa DOLE. Hindi naman na kailangan both under the new guidelines. And then as discussed, yung proof ng publication and with duly notarized affidavit that no Filipino applied or found competent, able, and willing for the position. So along with the proof of publication, kailangan na mag-submit ng notarized affidavit na walang Filipino nag-apply or na-consider for the position ng foreign national. And then other documentation to verify the qualification of the foreign national. So pwede dito mag-submit ng kanyang diploma or previous work experience, certificate of employment niya from previous employers, or yung kanyang mga professional licenses and certificates ng mga specialized trainings. And then yung specific additional requirements for covered establishment. So for construction companies, we also require the submission of the Philippine Construction Accreditation Board or PCAB license, or yung ini-issue ni DOLE na Certificate of Registration for Contracting and Subcontracting Arrangements under DO 174. And then for mga online gaming, we require the license, accreditation, or appointment from the Philippine Amusement and Gaming Corporation or PAGCOR or other authorized free port or economic zone na may power na mag-issue ng license to online gaming. And then for practice of regulated profession, we require a special temporary permit issued by the Professional Regulations Commission or the PRC. And then for employers covered by the anti-dummy law under foreign investment negative list, we require the submission of the authority to employ alien issued by the Department of Justice. And then for mining, authority to hire foreign national or AHFN issued by the Department of Environment and Natural Resources, specifically yung Mines and Geosciences Bureau. So for foreign nationals engaged in mining operations. And then for the fees, mapapansin na mas mababa na yung fees kasi tinanggal na yung publication ni DOLE na 4,000 pesos. So for 1 year of AEP validity, 6,000 pesos, and then for additional year, 5,000 pesos. And then for renewal of AEP, the same fees also apply. So 6,000 pesos for 1 year, and then additional year, 5,000 pesos. So maximum period per AEP application is 3 years, 1 to 3 years of application per foreign national. And then this can be extended for 1 to 3 years of validity. Okay, still under Rule 2, it also speaks of objections to an AEP application. So under Section 7 of Rule 2, it states that a person or entity who stands to be adversely affected by the approval of an AEP application may file an objection in writing with the DOLE Regional Office where the application is filed. So the objection must state or specify the grounds as to why no AEP should be issued in favor of the foreign national. More importantly, it must clearly indicate that the objecting Filipino citizen is competent, able, and willing to perform the job or jobs to be performed by the foreign national. This is to avoid nuisance objections. So on Filipinos or entity na gusto mag-object dun sa approval ni DOLE for the issuance of an AEP for a specific foreign national, may go to the DOLE regional office concerned to file for an objection. So magiging basis din, i-check din namin yung basis ng objection, and then pwede itong maka-affect sa approval ng AEP for that specific foreign national. Lalo na kung yung Filipino na yun ay talagang qualified for the position at talagang gusto niyang and willing siya to perform the work being offered to the foreign national. So this is without prejudice to the regional director's discretion and may be subject to further proceedings such as the conduct of a clarificatory conference. So pwedeng ipatawag lahat ng parties involved sa DOLE office via the clarificatory conference. Okay, still under Rule 2, evaluation and processing. So Section 8 and 9 of Rule 2 provides for the evaluation process and validity of the AAP issued to a foreign national. So in evaluating an AAP application, our evaluators are guided by Section 8 ng DO 248, which states that the regional office shall, number 1, verify whether or not the publication requirement has been complied with. This can be verified through the documentary proof submitted by the applicant. And then verify the information and declarations in the application and the authenticity and due execution of the supporting documents. So this will be based on the submitted documents by the employer or the foreign nationals during the AAP application process. So pwede namin i-check and i-verify yung mga information doon and kung totoo yung mga dineclare na information doon. And then evaluate the employment contract and its consistency with the published qualification requirements for the vacant position. So kung yung nakasaad sa employment contract ay yun talaga yung details or information na nilagay during sa publication ni employer. So dapat nagma-match yung information ng publication and sa employment contract na in-execute. And then evaluate, consider any objections, as mentioned earlier, receive whether these are meritorious and timely filed, and then determine the validity period of the AP applied for. So the DOLE regional office has the power to determine the period of validity to be granted to the foreign national, sa AP ng foreign national. And as deemed necessary, require personal appearance, call for clarificatory conference, or conduct a verification inspection of the employer's premises and place of work of the foreign nationals. So this entire evaluation process is crucial because this is DOLE's first line of defense from bogus and fraudulent or erroneous applications being submitted to the regional offices of DOLE. And then Section 9, on the other hand, provides the timeline within which the regional office should process and act on an AP application. And then the same section also provides for the validity period of an AAP, which is, as mentioned earlier, 1 year unless a shorter or longer period is specified in the employment contract of the foreign national, but in no case shall exceed 3 years per application. Okay. Still under Rule 2, yun medyo mahaba yung Rule 2 dun sa DO 248. So the DOLE Regional Office may conduct a verification process to ensure the legitimacy of a company's application for an AP. So this is also to confirm that the company is legally registered and operational in the Philippines. So if necessary, the DOLE may conduct on-site inspections to further verify the company's operations, facilities, and employee records. So the goal is to ensure that the foreign national's position is legitimate, necessary, and aligns with the labor market test and the economic needs test. Ultimately, babalik ulit tayo dun sa start ng ating presentation, protecting the integrity of the AP process and safeguarding local employment opportunities for the Filipinos. So in addition, this process aims to ensure that the declarations of the applicant in its AP applications are true, such as the declared place of work where the foreign national is intended to be deployed. Kung doon talaga siya ma-assign and kung meron ba talagang place of work or may office doon sa dineclare nilang place of work ni foreign national. So a key component of this verification process is also ensuring immigration compliance for the foreign national. So DOLE will also check the foreign nationals' immigration status to confirm that they possess the necessary work visas and permits, ensuring that they are legally authorized to work in the country. So this compliance check is crucial in preventing illegal employment and ensuring that foreign nationals or foreign workers are hired under appropriate immigration regulations. And still under Rule 2, nandito rin yung utilization ng DOLE of the economic needs test. So this is one of ito yung mga bago doon sa ating DO248, yung economic needs test. This is to determine the suitability of employing a foreign national. So yung pag-assess ni DOLE will be based on these factors. Number one, labor market conditions or the shortage or surplus of Filipino workers in the relevant sector. So pwede itong national or regional na data or labor market information na dito magbabase yung ating regional offices. Ayan. So number two, another consideration is the availability of necessary skills and expertise within the local labor market. So this will be done through consultation sa mga key stakeholders along the region and pwede din sa national level kung ano yung mga emerging skills na wala pa talaga dito sa Pilipinas na magiging ground para payagan natin yung foreign national na yun makapasok ay makapagtrabaho sa Pilipinas para may bahagi niyo yung skills na yon with our local labor market. And then finally, the national economic interest or the foreign nationals' contribution to the development, competitiveness, or technological advancement of the sector, especially for incentivized employers or those in priority industries. So essentially, this process allows the Department of Labor to assess and determine whether the applicant complies or passes the labor market test or economic needs test in approving or denying an AEP application. So it can be said that the economic needs test complements the labor market test as it assesses the economic impact of employing a foreign national. So this test ensures that the employment of foreign nationals align with the country's broader economic objectives, and then the ENT evaluates whether foreign expertise in a particular field will stimulate innovation, productivity, or investment in the Philippines. So for example, a foreign national may be required in an emerging technology sector where their specialized knowledge will have foster industry growth, which will lead to job creation and skills development for Filipinos in the long term. So yun yung importance. Though medyo nagpo-formulate pa rin si DOLE on how to conduct economic needs test, but this will be an internal procedure within the department. Okay. Still under Rule 2, yung denial of application. This is under Section 10 of Rule 2. So DOLE may deny an AEP application for reasons such as number one, misrepresentation, fraud or false statement, then ineligibility due to previous and subsisting disqualification, and then non-compliance with labor market test or economic needs test, and then lack of necessary permits from competent agencies, or yung kanyang lack of license or permits or authorities issued by other government agencies. And then meritorious objections from Filipino workers. And then involvement in malfeasance by the foreign national or commission of a crime by the foreign national, by the employer or the foreign national. So moreover, a denial based on any of the grounds in paragraphs A, B, and F, ayan yung naka-highlight, A, B, and F, may result in a 5-year disqualification for both the foreign national and the employer. So if after due process, nakita na nag-violate nga si employer and foreign national, they will be disqualified to apply for an AEP for 5 years. Ayan. So these rules and procedures for denial shall also be applied sa applications for certificate of exclusion and exemption, which later on we will discuss since nasa separate rule yung exclusion and exemption. Okay, so we go now to Rule 3, which is the renewal application. So take note also that the rules and documentary requirements for new applications are the same for renewal, except na sa application form for renewal, dapat duly notarized yung application form. And then further, all material information and required clearances, licenses, permits, or other documents from competent authorities must be updated. So dapat ni-renew na rin nila yung kanilang mga licenses, clearance, and permits from and other documents sa ibang agencies. And then likewise, renewal application must still comply with the publication requirements. So this is one of the key changes for renewal na kailangan mag-post pa rin sa 3 media yung mga applications for renewal. And then in case that the AAP was issued subject to the implementation of the understudy or SDP, an accomplishment report jointly signed by the employer and the foreign national, including the assessment and evaluation of the understudies duly signed by the latter, must also be submitted. So later we will discuss yung understudy compliance. So almost the same lang yung mga documentary requirements for renewal natin as flashed on your screen. Okay, so we go now to Rule 4. So Rule 4 covers the grounds and procedures for cancellation naman and revocation. So let's go muna dito sa cancellation. So the DO248 provide that an AAP may be cancelled by DOLE motu proprio on the ground of employer or foreign nationals unexplained or inexcusable failure to number 1, claim the AAP card within the prescribed period, which is 10 working days, and the submission of the proof of re-election or reappointment when required. This happens when sa mga elective position na hindi agad sinubmit sa DOLE yung kanilang proof. And then additionally, an employer may request the cancellation of an AAP under the following circumstances. So number 1, closure of business or cessation of operations, resignation or separation of the foreign national, and then yung non-renewal of the term of office. A foreign national may likewise request for the cancellation of his or her AAP with clearance or conformity by the employer. And finally, in case of additional position, an AAP is considered canceled upon the issuance of the new AAP for additional position. So in all cases, the cancellation shall be done through an order of cancellation to be issued by the regional director, which shall include the directive to surrender the cancelled AAP card to the regional office. And then Rule 4, we're still on Rule 4. We go now to the grounds for revocation. So the DOLE regional office, upon complaint or motu proprio and after the conduct of due process, may revoke an AEP for reasons such as misrepresentation, fraud, and false statement in securing the AEP. So, and then contract substitution, criminal conviction, failure to comply with training programs, or violation of relevant rules under DO248 and other policies governing the employment of foreign nationals. So revocation procedure shall at all times observe due process, which may be done through clarificatory conferences, personal appearances, or inspection. So as a result of a revoked AEP, the foreign national and employer may be disqualified to reapply for an AEP for a period of 5 years or 10 years, depending on the ground which the revocation is based. So flash on your screen yung appropriate na disqualification for kung anong grounds for revocation yung mawa-violate na employer or ng foreign nationals. So for grounds A, D, and F, 5-year disqualification. And then for B, C, and E, 10-year disqualification from applying for E. And then Section 4 of Rule 4 provides for the procedure for revocation of AAP. So the procedure for revocation shall at all times observe, of course, due process and shall be in accordance with the following. Within 10 calendar days from the discovery of the ground for revocation or from receipt of the verified complaint or petition for revocation, the DOLE Regional Office shall notify and furnish the employer and the foreign national a copy of the evaluation report or the verified complaint or petition, as the case may be, with directive for the latter to submit a verified answer and supporting evidence within the non-extendable period of 10 calendar days from the receipt of notice and setting 2 hearing dates for them to attend and be heard. So the DOLE Regional Office shall complete the proceedings within 30 calendar days from receipt of the verified answer, after which the case shall be deemed submitted for resolution. No motions to dismiss or for bill of particulars, postponement, or extension of time shall be entertained. And then within 30 calendar days from submission of the case for resolution, the regional director shall issue an order dismissing the complaint if it finds the verified answer and evidence submitted to be satisfactory. Otherwise, it shall issue an order revoking the permit. So every order or decision issued by the DOLE regional director shall state the facts of the case, the issues involved, the legal basis for the order, and the sanctions imposed or reliefs granted, if any. And then an order of revocation shall be deemed to include the deactivation of the AAP card and a directive for the employer or the foreign national to surrender the AAP card. And then still under Rule 4, it also provides for the remedies that can be availed by the employer or foreign national whose application was denied or whose AAP was revoked. So under DO 248, employers or foreign national may file for a motion for reconsideration, excuse me, with the regional director within 10 days from receipt of the order canceling or revoking an AAP. So an order denying the said motion makes the assailed order effective immediately. However, an employer or foreign national may still file an appeal to the DOLE secretary within 10 days from receipt of the order denying the previous motion for reconsideration. And then the secretary's decision, whether granting or dismissing the appeal, becomes final and executory within 10 days. And then this appeal process allows for review of the regional director's decision and provides an opportunity to address potential errors or inconsistencies. So these remedies and procedure are also applicable to orders denying an AAP application and those under certificate of exemption and exclusion. And then speaking of exemptions and exclusion, we go now to Rule 5. So Rule 5 talks about the categories for those exempted from AAP, which is enumerated on your left, and then those who are excluded from AAP, which are enumerated so on your right. So let's go to the exemptions first. So foreign nationals exempted from securing AAP in the Philippines include spouses of diplomats, personnel of international organizations, foreign embassy staff, peacekeeping personnel, and visiting professors, permanent residents, refugees, and those legally exempted by other laws. So these exemptions generally apply to individuals with specific diplomatic, official, academic, or legal statuses. Meanwhile, foreign nationals excluded from securing an AAP include board members with voting rights but no operational involvement, part owner, president, or treasurer subject to the anti-dummy law, and then intra-corporate transferee employed by a foreign service provider for at least a year, and then contractual service provider meeting specific criteria. And then those authorized representatives of foreign principals engage in recruitment activities through licensed agencies. So these exclusions generally apply to individuals with specific roles within companies or those involved in particular business activity. So at both of the categories of exemption and exclusion remain remain the same naman as before under the old rules or the 0221-21. So as to the requirements of a certificate of exemption, in applying for exemption from AAP, the foreign national must submit a duly notarized application to the DOLE regional office along with the notarized request, a photocopy of the passport bio page of the foreign national must be submitted. And then if applicable, a visa or alien certificate of registration or yung ACR card should also be provided as these documents establish the foreign national's legal stay in the country and ensure compliance with Philippine immigration laws. And then stateless persons are not required to submit these documents due to their unique legal status. So depending on the foreign nationals category for exemption, an additional documents may be required. So for spouses of diplomats, we require an endorsement from the Department of Foreign Affairs or DFA in order to confirm eligibility for exemption based on their dependent status ng kanilang diplomatic visa. And then for visiting professors, they must submit a copy of their agreement validating their academic purpose and exempted status. And then for refugees and stateless person, they must provide a certificate of recognition from the Department of Justice, which officially acknowledges their legal standing and grants them special exemption from the alien employment permit. And then lastly, for foreign nationals who are exempted by other laws, so a copy of the relevant law must be submitted to ensure the exemption is backed by legal authority. So altogether, these documents substantiate the foreign nationals' eligibility for exemption and guarantee that the request aligns with both DOLE regulations and relevant Philippine laws. And then for exclusion, the foreign national must also submit a notarized request to the DOLE regional office, but this time along with the employer's business or mayor's permit or certificate of registration. So these documents are essential for confirming the legitimacy of the employer's operation and their legal status in the Philippines. So same as sa exemption, based on the category, we require the following documents. So for board members and part owners, yung president and treasurer, they must submit a general information sheet and a secretary certificate to verify their role within the company. So dapat dun makikita yung kanilang position as elected board members or part owners of the company. And then for intra-corporate transferees and contractual service supplier, they must submit their authenticated employment contracts and relevant agreements to validate the nature of their employment and confirm their eligibility for exclusion. And then for authorized representative of foreign principals, they must submit an SRA, Special Recruitment Authority, and letter of authority from the Department of Migrant Workers to confirm their authority to act on behalf of a foreign entity. So upon receipt of the application, the regional office shall determine the completeness of the application and its supporting documents. So same as the AAP, if incomplete yung documents, they will be returned to the employer or the foreign national na applicant for completion and compliance. And then if completo, the foreign national shall be directed, or the employer and the foreign national shall be directed to pay the processing fee for certificate of exemption or exclusion, 2,000 pesos. And then note further that requests for exemption and exclusion are also subject to denial, cancellation, and revocation procedures and their grounds after due notice and due process. And then Rule 6, dito naman naka-enumerate yung duties and responsibilities of the employer and foreign national. So Section 1 of Rule 6 provides that the employer and foreign national are jointly responsible for ensuring compliance with all relevant laws, these rules, and the AEP conditions. So this include ensuring that the foreign nationals functions align with the approved position description na dineclare ni employer. Under this rule, it is expressly stipulated that foreign nationals shall perform their work at the designated work location as declared in their AEP application, with exemptions for employers' transfers or temporary assignments to related companies. So failure to comply with this may constitute a ground for revocation that may warrant the revocation of the AEP and imposition of fines per Rule 7. So both parties must also comply with any requests for appearance at the DOLE regional office on matters related to an ongoing skills development program or understudy training program. And then an employer is also required to regularly submit quarterly reports of its updated list of foreign nationals with AEPs to the DOLE regional office and promptly notify the office of any changes in material information. So this include yung employer details, foreign data ng foreign national or information niya, change in work locations, yung kanyang resignation or separation, and yung closure of business or cessation of the activity for which the foreign national was employed. And then if the foreign national's continued employment requires re-election or reappointment within the AP's validity period, the employer must submit a notarized corporate secretary certification confirming this, yung kanyang bagong position, at least 10 working days prior to the expiry of the original term. And then employers must also submit periodic progress reports on the implementation of the understudy training program or skills development program. Ayan. Speaking of the understudy training program, so under Rule 6, nandito sa DO 248, we introduced a new concept in line with the policy of promoting human resource development and ensuring the effective transfer of skills, knowledge, and technology to Filipinos. So ito yung understudy training program or skills development program. Pero nire-require lang, we want to emphasize that the requirement for the UTP and SDP will only cover those specific establishment na na-mention ko kanina. So number 1, those registered under the Foreign Investment Act and enjoying fiscal incentives. And then number 2, yung mga nag-ooperate ng public utilities. And then those belonging to strategic investments enumerated under Executive Order number 18. So hindi lahat ng employers na nag-hire ng foreign national ay re-require namin to submit an understudy. Good if magsasubmit kayo as merong initiative to transfer skills and technology sa ating mga Filipinos. Pero under these guidelines, we only require the submission of the understudy training program or skills development program under those covered establishment. So sa section 3 of Rule 6, dito makikita yung guide in the implementation of the UTP. So it states that the UTP must contain the following material information. So number 1, the objectives of the program, the specific skills and competencies to be transferred or developed to the Filipino employee, and then the duration of the implementation starting within 5 working days of the foreign national's employment and concluding no later than 5 working days before the AEP expires. And then at least 2 understudies per foreign national with proof that they are regular employees and that their roles are next in rank to the foreign national's position. And then evaluation standards and tools to measure progress with a schedule for periodic evaluation and reporting to the DOLE regional office. And then identification of a responsible person to oversee and evaluate the program, which should be proficient in human resource development and training. So inspections and monitoring visits will be conducted to verify that the UTP or SDP is being carried out according to the established plan submitted to DOLE. So we know that majority of the companies have HR na involved or nag-handle ng training sa kanilang mga organization. So if meron nang nakaset na trainings doon sa company na yan, that's fine. We want just to remind na dapat yung mga information needed na isasubmit sa DOLE is nandun. Medyo iti-tweak nyo lang siya ng konti para lang makita natin yung mga required information. So wala namang specific template for the submission of the UTP and SDP plan. Pero merong pinrepare si DOLE which can be accessed through your respective regional office para pwede nyo siyang gawing reference material. So flash on your screen is the sample understudy training program or skills development program plan na maaari nyong gawing reference in submitting the said plan during the AAP application. So we want to highlight also that this requirement is prescribed by the Foreign Investment Act and the Public Service Act, since the Foreign Investment Act binabaan yung ang tawag nito, yung capitalization for foreign nationals to own or operate a business to the Philippines. So ang magandang trade-off nun in order to maximize these investments or these investors ay also i-transfer yung kanilang specialized skills sa mga Filipino na employee nila dun sa kanilang business. So yun po yung main purpose ng understudy training program or skills development program, which is a mandatory requirement under the FIA. Okay, so next, Rule 6, records keeping. So we just want to remind that employers must maintain all employment records of the foreign national and make them available for inspection by the DOLE Regional Office at any time in accordance with applicable rules and regulations. And then, yung Rule 7 naman, nandito yung prohibited acts na ini-impose ni DOLE for violations. So, any act of misrepresentation, false statement, fraud, tampering, or other analogous or similar act that constitutes a ground for denial of an AP application under Section 10A and B of Rule 2. It can be recalled that Section 10A and B of Rule 2 refer to misrepresentation, false statement, and fraud in the application of AAP. So this will have a fine of 10,000 and disqualification of 5 years. And then, letter B yan, any act that constitutes a ground for revocation of an AAP under Section 3, paragraphs A, B, C, and E of Rule 4 of these rules, and these are grounds for denial of application. So this also includes yung working under a fake or counterfeit AAP. So this is equivalent for a disqualification of 10 years and a fine of 10,000 pesos, both to sa employer and the foreign national. And then deliberate disregard or non-compliance with these rules is also prohibited, which will result to a disqualification of 10 years and a fine of 10,000, both the employer and the foreign national. So still under Rule 7, so for each prohibited act, both the foreign national and the employer, as mentioned earlier, may be fined up to 10,000 by the DOLE Regional Office, subject to due process. And then yung application bar, na-discuss na din natin. earlier dun sa previous slide. And then for Rule 8, yung management, administration, and enforcement. So DOLE will regularly review these rules to align with national development priorities and international commitments. And then i-enhance pa ni DOLE yung kanyang develop and improve yung kanyang alien employment permit management system, yung APMS, to ensure efficient and effective implementation of DO 248. And of course, we want to highlight yung strong compliance with labor standards, occupational safety and health standards, and other social legislations by employers hiring foreign national through its labor education and inspection and programs. So I believe that's the last slide. Maraming salamat po sa pakikinig and magandang hapon.
We deeply appreciate your comprehensive and enlightening discussion, Sir Wilmer, on the new rules regulating the employment of foreign nationals in the Philippines. In the presentation, the speaker highlighted policy objectives, giving preference for Filipinos, and emphasizes promoting the human resource development. He also provided an in-depth overview of the salient features of the new guidelines and also discussed the general provisions of the department order, the documentary requirements and procedures in applying for AEP, along with the applicable fees for the new applications as well with the renewal of application. And of course, diniscuss din yung requirements for the application for renewal and additional position, yung ating mga objectives to the applications, and grounds for cancellation and revocations of the AEP. Of course, with the discuss then the exemptions and exclusions, and he also emphasized the duties and responsibilities of the employer and foreign nationals. So at this point, we will now begin addressing the questions submitted during today's presentation. Our first question is, for renewal of AEP, shall we undergo with the 3 publication daw po ba, sir?
Yes, one of the new key changes sa renewal of AEP, we will also require the applicants to submit yung kanilang publication for the position of the AEP for renewal application. So this is to ensure na after nung kanyang validity ng kanyang new AEP is to check if may available na skills or Filipino na available within our local labor market to perform the function of the foreign national. That's why we require also yung publication for renewal. Thank you.
Thank you for that clarification, Sir Wilmer. And for the second question po, what will happen doon sa existing regular foreign nationals for the renewal ng AEP, tas meron pong nag-apply or nag-respond sa 3 publications?
Yes. So DOLE will check and validate if yung mga objections ng Filipinos dun sa renewal application ng foreign national, and we will call for a clarificatory conference and due process kung talagang meritorious objection yung sinubmit ng Filipino. Pero as to the company policy, if nakita nyo na may mga nag-a-apply sa inyo na Filipinos, of course, we also want to highlight again yung nasa first slide ko na under the Constitution, we give preference to Filipino in the employment, in the local employment, diba? So doon ulit tayo, doon yung magiging basis pa rin natin. We give preference to the Filipino. Thank you.
So thank you for that, sir. And next naman po, meron pa ba tayong next question? Next is, si Do lang po po ba ang may ENT or any related labor market test sa Pinas or meron ibang government agencies?
Yes, sa Philippines, si DOLE yung nagko-conduct ng labor market test. And now, under the new guidelines, we will also be introducing yung conduct ng DOLE ng economic needs test to ensure yung mga ginagrant na AAP dito sa Philippines, yung mga foreign nationals na nagtatrabaho dito, ay talagang nakakatulong sa economic activity ng ating bansa for innovation and other skills development or industry development. So yes, si DOLE lang yung nagkakonduct ng labor market test sa Philippines.
Next is there a model or mechanism that the Philippines adopted from neighboring countries or other nations that we see similar to the Philippines since this is the first time we implement CENT?
Yes, Ms. Gillette. Actually, yung DOLE Institute for Labor Studies is conducting a research paper or study regarding dun sa ENT and kung paano siya magiging effective na i-implement dito sa Philippines. And I believe their study will be based on how our neighboring countries implement the economic needs test. Thank you.
Thank you, Sir Wilmer. So for the fifth question po, Sir, what if ang foreigner worker ay toxic sa working environment, bully sa mga Filipino workers? Pwede po bang i-report ito sa DOLE?
Yes, ma'am. Opo, pwede niyo pong ilapit sa inyong DOLE field office or regional office na malapit sa inyo, and we will investigate, and later on if napatunayan after due process ay pwede po ito maging grounds ng revocation ng kanyang AAP and i-endorse namin for further process ng Bureau of Immigration.
Ayan. So thank you, sir, again. And next question, with regard po sa ENT, saan po natin nahanapin yung shortage or surplus of Filipino workers in relevant or identified sector? And yung availability of specialized or necessary skills and expertise within the local labor market.
So sa BLE, on the national level, we refer to the labor market information o yung mga publication regarding labor market na ini-issue ni BLE para dun sa mga hard to fill, example na hard to fill occupations or yung mga industries na may mga emerging skills. Pero as we know, yung different regional office, different regions natin within the Philippines ay may iba't ibang labor market. So we advise our regional offices to conduct also yung ENT within their area to evaluate kung ano talaga yung um, mas appropriate dun sa kanilang region, kung anong skills yung may surplus na madaming Filipino workers or kung ano yung skills na maraming shortage, and kung ano yung mga industries na talagang nahihirapan makahanap ng mga empleyadong Filipino. So this will all form part of the evaluation for the AEP. So dun natin ini-envision yung implementation ng ENT. And of course, dito sa central office, talagang de-develop pa namin on how we will collaborate, not only with our partner government agencies, but also with the private sector.
Thank you so much, sir. And for maybe for the last question na lang po. Tanong lang, sino ba ang responsable and allowed to monitor or check the compliance kung meron bang AEP and work permit ang foreign?
For foreign nationals working in the Philippines, ma'am, as to the permit to work, si DOLE po yan. Pero for the full compliance, if legally staying si foreign national, kasi as we know, yung AEP is only a part of um, was only a part of the requirements for a work visa. So to ensure yung compliance talaga ng foreign national, doon kung meron talaga siyang AEP and work visa, it will fall under the jurisdiction of the Bureau of Immigration. Pero as far as the AEP is concerned, si DOLE po iyan.
Okay. Next, marami pong mahabol na mga questions, sir. Talagang yung ating mga participants ngayon ay medyo na sila sa topic po natin ngayon. So, next question is, may required time po ba sa publication if ang renewal ng AEP is by January 2026 pa?
So as discussed earlier, yung publication po will only run is only valid for 45 days. So, yung i-timingan nyo na lang po dun sa pag-apply nyo ng renewal, dapat pasok po siya sa 45 days na validity period nung publication. Dun lang po, lagpas po ng 45 days yung sinubmit yung publication ng position, hindi po siya mako-considered sa AAP application. Dapat po pasok dun sa 45 days limit ng publication. And complete dapat dun sa tatlong ways na pinresent ko earlier sa newspaper, sa PhilJobNet, and sa Peso. Thank you.
Okay. So next, may visa din ba ang mga foreign nationals sa Pinas at parehas din ang regulations kagaya dito sa ibang bansa?
In the Philippines, ma'am, separate po yung work permit and visa. Yung work permit po ay si DOLE ang nag-i-issue, and then yung work visa po si Bureau of Immigration. Unlike dun sa neighboring countries natin, not all naman, meron ding similar sa atin, pero yung ibang countries, they issue yung work visa na diretso. Parang yun na yung kanilang permit and visa na prior entering the country, before ka pa lumabas from your home country, meron ka ng permit to work and work visa na dito mo pa lang, dito, masasecure mo na dito para pag-enter mo doon, meron ka na agad visa sa pagdating doon sa country of destination. Thank you.
Thank you, sir. Next is, if makomplete po ang understudy training program, what will be its effect sa application for extension or renewal ng AEP application ng foreigner na may completed understudy program?
Yes, ma'am. So, yung completion ng understudy training program, it will be a basis for the DOLE Regional Office to determine yung renewal ng AEP ng foreign national. If we saw, based on your report sa completion of the understudy, na successfully na transfer yung skills and competency ni foreign nationals dun sa Filipino understudy niya. So pwede namin siya maging basis or ma-question during AEP application na meron ng available skill or meron ng available Filipino worker na as declared by the company na successfully na-transfer yung knowledge and skills. So, pwede siya maging ground na sa decision if i-renew pa yung AEP. Pero we still rely on your needs dun sa mga company kung hindi pa successfully na-transfer yung mga skills required and kailangan pa i-extend yung services ni foreign national. It will also form part dun sa evaluation process if talagang successfully na uh, talagang nag-undergo ng understudy training program yung foreign national and yung kanyang Filipino counterpart. So magre-rely talaga tayo dun sa magiging evaluation during the renewal application.
Thank you, sir. And need pa po ba mag-understudies ng bago mag-AEP renewal? If need po, saan po dapat gawin?
Same ma'am, for renewal of AAP, if as mentioned earlier, need pa rin ng understudy program at i-continue yung understudy training program. So, during the application for renewal, magsasubmit pa rin kayo ng understudy training plan dun sa duration nung renewal ng foreign national. So kung ilang years ulit yung i-request yung for renewal, halos ganung timeline pa rin yung isasubmit yung understudy training program for the renewal application. Kasabay po yun ng renewal application.
Okay, thank you, sir. And for the last question, I guess, ang mga foreign national ba na may 9D visa or 3D trader ay required ba na mag-apply ng EEP or pwede silang mag-apply ng exemption?
For 9D visa holder, we require them for AEP, ma'am. Pag 9D visa holder, unless they are hindi exemption, exclusion. If they hold yung mga executive positions or member of the board, yung mga 9D visa treaty traders can apply for exclusion. Pero under exemption, wala po sa category ng AEP yung 9D visa holders. Only permanent resident visa holders. So hindi siya under the 9 visa category, dapat under 13 visa category or yung immigrant visa category po natin. Salamat po.
Thank you po, Sir Wilmar. So that's all for today. And maraming salamat po sa lahat ng nag-submit ng questions ngayong araw. Thank you then, Sir Wilmar, for addressing the questions and for all the clarifications. And for questions that we weren't able to address, rest assured po that our social media team will reply to your inquiries. And that concludes our Webinar Wednesday for today. And I believe that it has been a productive session because we learned a lot from our esteemed resource speaker. And again, thank you so much, Sir Wilmer, for gracing us today and taking the time to discuss with us the Department Order number 248 series of 2025, or the new rules and regulations on the employment of foreign nationals in the Philippines. Our Webinar Wednesday doesn't end here. We will have our next episode, episode 11 on April 9, with the topic of Annual Establishment Report on Wages. If you have further questions, you may send us an email through ask@bwc.dole.gov.ph, or you may call the DOLE hotline at 1349. Please follow our Facebook page, BWC 1949, para maging updated kayo sa iba't ibang issuances, announcements, and activities na inilalabas ng BWC at ng DOLE. We look forward seeing you again live here on our Facebook page, facebook.com/BWC1949, every Wednesday at 2 p.m. Again, this has been Michelet Fajardo, your moderator for this program. In behalf of the Bureau of Working Conditions, thank you for joining us today. See you again in our next episode.
Para sa mga katanungan at karagdagang informasyon, maaari po tayong tumawag sa DOLE Hotline 1349 o sumuli sa mga DOLE Regional Field Office na nakakasakop sa inyong lugar paggawa.